let's just start with your reaction to the fact there's going to be a mediator here. What is your opinion on that? Are you for that?
Well, we've been asking for that since the beginning. I think that would have been a helpful addition from the very beginning. This is the first sign of interest, or serious sign of interest, I guess, I've seen. I would have liked to have been consulted about what the plan was, because usually both sides have to agree that it's productive and going to be held in a productive manner. And the problem we have here is trust when we don't have a full board that can go out and vote in open session. So
while you still have this, the hearing's still set for Monday, you're still pushing for a judge to enforce the $4 million settlement. Is that correct? Okay.
Yes. But look, we're happy to keep talking and see if there's some other way of resolving it, like we have been. And I welcome the presence of a mediator. I don't necessarily think that the arrangement they've come up with today is the most productive way to do that. But if those are the terms that they're offering, then we'll consider it, and we'll probably participate, because I always think continued discussions can't hurt. So.
Was there any offers offered today?
No. I was not spoken to once until they told me they were coming out of closed session. So when you learned of it is when I was learning of it. So.
Gotcha.
So what specifically with this arrangement do you not like? I mean, because Moss was saying that, council is going to work with you to select a mediator, right? I mean, what about the arrangement?
So that's typical. Usually both lawyers agree on who they're going to use as a mediator, and I have no doubt there's a lot of qualified mediators in the area. I'm sure we can agree on somebody. So that's not a controversial prospect. But the fact is, whenever you're negotiating with a board, typically you have to have faith that who's ever negotiating on behalf of the board knows that the board is going to approve what they're recommending, what the agreement that's been come to. And it's not, in the typical sense, it has to be voted on in a public meeting. Here, I don't know if the subcommittee they've appointed, if they agree to something, if they'll come back and the board will deny that, or say we're not interested in agreeing to what the subcommittee's approved. So that's the problem here.
When this new mediator is now, once that's all done, is it going to be back to square one, or are you guys going to work on that $4 million that we all heard about?
Well, so our position is the parties are starting from different positions than they were the first time we negotiated. We think we're entitled to win this motion, and so we think we're in a different position. We also think if we're talking about an agreement where my client comes back, she's going to need some protection, that she's not going to be facing another termination hearing in a month. And if they're not willing to offer that protection, that's not going to be a deal that we're interested in. So, and right now, I don't know what's going to be on the table, or if we'll have any discussions before then. But look, I'm willing to keep talking. I've wanted a mediator the whole time. So if we'll go and talk. But I question how much we can get done when you don't know if the whole board's going to approve the deal or not. And this would have been, I've been here all day with my client, and I've not been talked to, and just sort of made the assumption that this is the thing we would think was a good idea. So we'll have to talk with them about what this is going to look like. But if they're willing to mediate, I will accept that as hopefully moving in a good direction, and we'll make every attempt to work with them on it. So.
From your understanding, would the subcommittee sit in on those mediator meetings?
Yeah, so the way it would work is usually the way it works is both sides meet in separate rooms, and the mediator goes between the two rooms and shuttles offers or tries to facilitate, maybe gives ideas to the party, hey, parties, what if you did this or what if you did that? Sometimes all the parties meet together in one room, but a lot of times each side is in its own room and you're sort of shuttling offers back and forth. So I expect that's what this is going to look like, but that's one of the things we're going to have to talk about.
It seems that at one point you thought you found common ground with the other side, and as you said, now you're saying that they've been trying to back out of this deal. Do you feel like you can find common ground with them through a mediator?
I don't know. I just don't know. So, there's no harm in continuing to talk while we're waiting for the judicial process to play out with our motion. So we'll do that, of course. We'll see what the judge says Monday when we go to the hearing, and again, there's no harm in meeting to talk, other than, I suppose, whether it's a waste of time or not. But I'll certainly go and talk with them with an agreed upon mediator, so.
Any idea how soon?
No, so, usually, again, this process can take, in my experience, about 6 to 8 weeks to agree on a mediator and then find a date. Because once you agree on a mediator, or you've agreed on a list of 3, you have to call and see when is that person available, and when, we have a subcommittee of 5, we have the Colemans, we have me, we have Addie. All of those people have to be able to converge on one date with a mediator that mediator that we have selected who also has that date free. So it can take 6 to 8 weeks to get a date. Now, if we have 2 or 3 people we're willing to use, maybe we get a sooner date.
And with the removal hearing still continuing on?
Well, my understanding from watching closed session or open session like all of you guys is that they have sort of stayed the hearing pending this mediation. So my assumption is we're going to pick a date as soon as everybody can do it and hope that that's sooner rather than later, and then they'll pick up the hearing after that. But I don't have any control over if they'll renotice the hearing or what will happen.
How does Addie work under these conditions?
I mean, it's, I would find it very difficult if I were her. She is, she's a stoic leader who's now been doing this for almost 11 months. So I think she's gotten used to, in some sense, operating under these conditions, but they're certainly not ideal, right? She spent the whole afternoon here. We've not accomplished anything. She's trying to do some work here while we're waiting. But it would be really nice if she could just go back to the regular business of the health department. We would all like that. But
Is this subcommittee idea, is that unusual at all in mediation or not really?
It's not. I've seen it before, but it's not. It's unusual. But I have seen its use before. When that's the board, when the board decides that's how they want to negotiate. Often it's the insurance adjuster. Here we know they haven't notified the insurance company, so I don't think we have that availability here, but oftentimes it's the insurance adjuster. So, but I've seen the subcommittee used before, certainly. Because then you don't have a quorum, but you feel like you have a fairly cross-section representation of what the board might do. So you avoid the quorum issue. You don't have to have a mediation and closed session. So, and I will concede there are some benefits to that. I don't like everyone having to sit out here and wait all day for what's happening when you don't know what. It's frustrating not to know what's happening and going on. So it would be ideal if we didn't have to meet in closed session. So, but anything else?
That's good. Thank you.
Thanks, guys.
Appreciate it.